Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-7010 et al. Rosalie Simon et al. Versus Republic of Hungary and Magyar Állampasuták ZRT, MAB ZRT appellants. Mr. Silbert for the defendants appellants cross appellees Republic of Hungary et al. Mr. Zell for the plaintiffs appellees cross appellants Rosalie Simon et al. And plaintiffs appellants Stephen Heller et al. Nationality issues. Mr. Weinstein for the plaintiffs appellees cross appellants Rosalie Simon et al. And plaintiffs appellants Stephen Heller et al. Lack of immunity under the 1920 Trianon Treaty.
Good morning, Mr. Silbert. You may proceed when you're ready.
Thank you, Your Honor. Good morning, and may it please the court, Greg Silbert for Hungary. So there are only two possibilities here. Either the plaintiffs were Hungarian nationals at the time of the alleged takings, or the plaintiffs were not Hungarian nationals. And either way, there is no jurisdiction over their claims. If the plaintiffs were Hungarian nationals, which is what they asserted and this court held in Simon 1, then there's no jurisdiction under the Supreme Court's decision in Philipp. If plaintiffs were not Hungarian nationals, that means they were either Czechoslovak nationals or stateless. So let's first assume that there were Czechoslovak national plaintiffs. Now, as we know, we've argued in our briefs, there were not Czechoslovak national plaintiffs, but let's assume that there were some. In that event, their claims would be barred by the treaty exception because Article 26 of the 1947 Peace Treaty provides the exclusive remedy for the same property losses that plaintiffs assert.
But part of our reasoning in Simon 1 was that the treaty remedies, the Treaty of Peace remedies were not exclusive. And why doesn't that stand whether the plaintiffs fall under Article 27, because under Hungarian jurisdiction, which might not exclude people who are Czechoslovak nationals, and or apply if they are Czechoslovak nationals and therefore governed by Article 26.
So thank you, Judge Pillard, for two reasons. And as the court, I think your question acknowledged, Simon 1 made that determination of non-exclusivity as to Article 27. Article 26 is a different provision.
But isn't Article 40 also?
Well, Article 40 was the provision of the treaty that involves state-to-state negotiations for disputes under Article 27. There's a separate provision of the treaty that involves disputes under Article 26. Those are not fed to Article 40. But I think most importantly, there's unique text of Article 26. And also the court's analysis in Simon 1 depended very heavily on the plaintiff's Hungarian nationality. So let me begin with the text of Article 26. There are several unique provisions of Article 26, not in Article 27, that show that Article 26 was exclusive. Number one, Article 26.8 says that Hungary and the property owner may agree on alternative arrangements in lieu of the provisions of Article 26. Now, if Article 26 were not exclusive and a claimant, a plaintiff, were free to assert claims for the same property losses without agreement by Hungary, then a provision saying that the property owner and Hungary could agree on alternative arrangements would make no sense and do nothing. So that provision shows that Article 26 is exclusive. In addition, Article 26 contains a substantive compromise of rights. It says that in situations where the property cannot be returned, which is what the plaintiffs allege here, that the claimant will receive in Hungarian currency 2/3 of the replacement value of the property. Again, if the plaintiffs were free to assert claims in another forum for 100% of the value of the property, which is what the plaintiffs are doing here, that substantive compromise would have no effect, right? If the Article 26 says if the property cannot be returned, you get 2/3 of the value of the property, they have to be assuming that provision will have some effect on the plaintiff's recovery, and that means that the recovery is in Article 26 and not an alternative forum. In addition to that, there is an express forum requirement and a time requirement to bring the Article 26 claim. So it says that Article 26 says all these provisions that I'm referring again are unique to Article 26, not in Article 27, not in the Court Simon 1 decision. Article 26 says the application shall be made to the Hungarian authorities. Obviously, this application before you today was not made to the Hungarian authorities. It also says that the application shall be made within 1 year of the coming into force of the treaty, unless the claimant can show that it would not have been possible to bring the claim earlier. So Article 26 unique text contains a time requirement and a specific forum requirement. And again, those provisions show that the intent of the treaty was for Article 26 to provide an exclusive remedy. In addition to that, those are all textual clues about Article 26. In addition to that, as we've said, and as this court acknowledged in Simon 1, it is in the nature of a peace treaty to resolve claims by the signatory nations and their nationals against the belligerent nation. The only reason that the court found that Article 27 was not an exclusive remedy was that Article 27 addressed claims by Hungarian nationals.
I don't read that to be the only reason. I think that they said in its terms it wasn't exclusive, and the same could be said about 26. I appreciate the arguments you've made about the text.
Fair enough, Your Honor.
But that decision's been vacated.
Yes, it has. It has.
So what precedential value?
Well, Simon 2 was vacated. Simon 1 was not vacated.
Oh, okay.
The holding of Simon 1 was reversed in Philipp, but the decision itself has not been vacated.
To what extent does the executive agreement bear on your argument?
On the executive agreement, the 1947?
No, it's 1973, wasn't it?
Oh, the 1973 treaty. The 1973 treaty is an example of a state-to-state negotiation under the terms of Article 26 that show how Article 26 is enforced. So Article 26, it gives a private right of action for claimants to seek redress from Hungary by applying to the Hungarian authorities. The treaty also says that if there's any dispute about the rights under Article 26, then there is a state-to-state process by which the interested governments can resolve claims for themselves and their nationals. So there have been a number of those state-to-state agreements pursuant to Article 26, where in addition to whatever private claims were made, Hungary paid additional restitution to the governments of nationals whose property was taken. And that executive agreement that Your Honor refers to, the 1973 agreement, is one such agreement between Hungary and the United States. Hungary entered into other Article 26 agreements with other nations, including the United Kingdom, including Canada, a number of different nations. So there have been, in addition to whatever private claims were paid, there was a number there were payments made under those state-to-state agreements. What that shows again is that the scheme that is envisioned by Article 26 is a scheme of direct claims made to the Hungarian authorities or alternatively state-to-state negotiations. It leaves no room for the litigation that you have in front of you, which complies with none of the restrictions of Article 26, does not meet the forum requirement, does not meet the time requirement, plaintiffs have not said that they would be limited to 2/3 of the value of the claim. This is a separate kind of proceeding to address the exact same property losses that Article 26 does not allow.
You argue quite at length about the commercial nexus requirement. And on the question of tracing the property that plaintiffs have identified back to the originally expropriated property, if the burden is, as you say, on the plaintiff from beginning to end, wouldn't that effectively nullify the FSIA's expropriation exception? If just all a nation state would need to do is liquidate the property and it would become impossible to trace. And as I understood it, there's a burden shift to take account of that, where the plaintiff needs to come forward, but then the burden is on the nation state to show that the property is not traceable. Is traceable.
Thank you, Judge Pillard. Yes. So as to that provision, this is a statutory interpretation question, right? So the analysis begins with the text of the statute. The relevant text is property exchanged for such property, right? So there has to be an exchange relationship, a path of exchange that exists between the property that the plaintiffs rely on to create FSIA jurisdiction and the specific property that was taken from a plaintiff. Now, Your Honor asked about the burdens there and nullification. 2 points on that. First point, remember, this is a foreign cubed lawsuit, right? This is a foreign, the allegation is that a foreign defendant harmed a foreign plaintiff in a foreign country, right? So in the ordinary course, there would be no U.S. jurisdiction over that kind of claim. For U.S. jurisdiction to exist, which is the exception, there would have to be some kind of substantial connection to the United States. And that's what this exchange relationship gets at, right? So as to what that connection is and then what the burden is, it's not any property in a sovereign's possession after an expropriation that creates a substantial connection between the United States and wrongdoing that occurred decades earlier. And let's be absolutely clear.
So the defendant would be able to show, no, the property in question does not trace back, or the U.S. property does not trace back to the expropriated property, because here's what we did with the expropriated property. It has nothing to do with these contemporary connections with the U.S. that the plaintiffs are pointing to. I mean, that's something that is really only in the capability of the defendant to do. And so if a defendant wanted to protect against, I mean, there are many situations in which defendants, nation states, companies, individuals want to shield themselves from jurisdiction, but they're the only ones who are really in a position to make that showing.
True. So,
and in the absence of that, doesn't our case law basically say you've commingled and now you have this commercial relationship, raises a presumption that's on the defendant to rebut that there is this, that the commercial activities of the defendant are using that property.
So I don't think this court's case law goes so far, Judge Pillard, but even if it did, this court's case law that you're referring to, I think Simon 1, was before Helmreich, right? So remember, then we have the intervening decision by the Supreme Court in Helmreich. And Helmreich said it's not enough that there might be jurisdiction or that you have a good argument that the jurisdictional facts are present. You have to show that the plaintiff has to make a valid claim that the jurisdictional facts are in fact true, right? Now,
Eventually, the facts have to be proved, and it is on the district court to establish the jurisdictional facts early. So were we to remand, it would be up to the district court as a factual matter to play this through. But I'm not sure I agree with your reading of Helmreich. It seems to me that Helmreich is about the distinct situation where the merits and the jurisdictional issue really are overlapping. And we, I guess, looked for some way to see daylight between those. We said, well, plausible claim a la Bell versus Hood is enough to establish jurisdiction. And then you have to have a valid claim for purposes of 12b6. That's all in legal terms, whether something is plausible or valid. I don't think it touches the Twick ball, if you will, plausibility standard, which is about facts. And I take your point that the facts, we're in an immunity domain, so the facts need to be resolved, but those haven't been resolved by the district court here. And why isn't it open to the district court, and in fact, the obligation of the district court to address this nexus question as a factual matter based on the pleadings?
So there's sort of two questions there. Let me take them in turn, Your Honor. I understand, I think, the reading of Helmreich that you're pointing to. There's some additional language in Helmreich that talks about kind of the affront to a foreign sovereign of exercising jurisdiction over claims when the jurisdictional facts are not actually there, not actually present. The predicates for jurisdiction might exist, but don't actually exist. So let me take that back to the statutory language. The statutory language is property exchanged for such property. So there has to actually be an exchange relationship between those two pieces of property.
But that's something that just can't be resolved other than through factual determination.
Well,
if it's plausibly pleaded, and that gets back to the discussion we were having about the shifting burden.
Very sorry to interrupt you, Judge Pillard. Yes, that goes exactly to the burden shifting framework that you mentioned earlier. The initial burden, as this court said in White Oak, is on the plaintiffs, and plaintiffs have to both make allegations and produce evidence that an exception applies. At that point, the burden shifts to Hungary. So we don't think, with respect to property tracing, that the plaintiffs have alleged or produced evidence that any exchange relationship exists between property in the United States and Hungary's property. But even if they had, Hungary did produce evidence, as the district court noted, from a number of respected scholars showing that it would be impossible to trace any property in the United States or currently in Hungary's possession to property that was expropriated from these named plaintiffs. So
I think we can agree that the district court has not made fact findings on this. The district court, I think, erroneously rested on allegations on this point, where if the pleading is sufficient, she needs to go a step further. Do you agree with that?
I do agree with that. I don't think the pleadings were sufficient.
I hear you.
Yeah, I know you know our point on that, Your Honor. And I would just say that Your Honor's observation is correct, not only of property tracing, but of other aspects too, including the court's findings of Czechoslovak nationality, right? The court said, well, it's not impossible that somebody might have been a Czechoslovak national, but that wouldn't do it. If she is going to pin jurisdiction on Czechoslovak nationality, which again, we don't think she can for the reasons I started with, treaty exception, there would have to be an actual finding that the plaintiffs were Czechoslovak nationals, not just that the pleadings don't 100% exclude that possibility, which is essentially what she found.
And on the Czechoslovak nationality, you lean heavily on this permit requirement, but aren't you over-reading that to apply to plaintiffs in this situation? Doesn't Article 62 and the permit requirement you talk about just apply to individuals who acquired rights of citizenship of the state that previously controlled territory, for instance, Hungary, between 1910 and 1918?
Well, I think that means acquired rights of citizenship in Czechoslovakia after 1910, which all of these plaintiffs would have, because they were born after 1910. And
but what if they acquired them after 1918? Then that permit requirement applies.
I don't think it cuts. It just says anyone who acquired rights of citizenship after 1910, which would be all of these plaintiffs. And then the thing about Article 62 that is significant is it applies the permit requirement specifically to people who have acquired rights of citizenship in territory that was ceded to Czechoslovakia by the Trianon Treaty. So it's not all of Czechoslovakia, it's that specific territory. And if you look at page 22 of the plaintiff's reply or surreply, I guess it is, they tell you that the territory that they're talking about, Subcarpathian Ruthenia, was ceded by the Trianon Treaty, and they give you some specific treaty provisions to do that. So that Article 62, I'm sorry, you're right.
I think I have my dates and my sequence wrong, but when I was reading the briefs, my impression was that it wasn't clear that requirement of getting a permit was applicable.
I believe that it is. I don't think that even the plaintiffs have argued any kind of date restriction on that provision. So I don't think that issue is before you. But even if you wanted to raise it sua sponte, I think that I don't have it right here in front of me, but I think what that provision says is acquired rights of citizenship after 1910, which all of these plaintiffs would have.
And what's your position with respect to statelessness? You started out earlier.
Thank you very much, Charles.
And then
Yes,
how that
I know we're
integrates
almost out of time here, but
We'll give you time.
thank you, Judge Pillard. I appreciate it. So as to statelessness, here's what the Supreme Court said in full. It said, a taking of a foreigner's property implicates the international legal system because it constitutes an injury to the alien state of nationality. And that is the principle of international law that is reflected in the domestic takings rule. So a stateless person, by definition, is someone who does not have a state of nationality, right? So a taking from a stateless person is an injury to that individual. It is not an injury to another sovereign state. And the international law of expropriation is triggered solely by injuries to another sovereign state. That's what the third restatement tells you explicitly at section 713. Our friends on the other side, they point you to the second restatement, section 175. That provision also refutes their argument. Okay, so if you look at section 175, it's in a sequence 174, 175, right? 174, and these are general provisions about international law overall, not the law of expropriation in particular, but even as to international law generally, section 174 says a violation of international law may be asserted by the nation of which the individual is a national, but not any other nation, right? And then 175 follows up and says it may not be asserted by an individual against the state, except, and then it gives you three exceptions, right? A, B, and C. Now, none of those exceptions are the international law of expropriation, which is, the Supreme Court told us in Philipp, the body of law that the expropriation exception references.
So
right?
I have a question that may or may not be a bit academic.
Okay.
I mean, I take it that on whatever theory of statelessness the plaintiffs here want to proceed, they have to point to law, likely customary international law, to support it. And they may, that's a steep climb. But just conceptually, isn't the question about whether you're stateless or the national of another state, doesn't that go more to remedy than to the illegality or not of the taking? In other words, international law remits individuals to state discourse to receive relief. So someone who is stateless might not have a remedy under international law because they have no sponsor, no state to speak for them. But arguably, the Foreign Sovereign Immunities Act is itself a congressionally created remedy. And therefore, if I'm right in my suggestion that the expropriation may be just as unlawful, but not have a remedy in international law itself, why wouldn't that suffice to provide a remedy if the FSIA explicitly creates one?
So it's more than remedy, Your Honor. International law governs the relation between states. Now, as the Supreme Court told us in Philipp, after the war in particular, there were some developments, especially in the areas of human rights law, where international law came to address the treatment of individuals.
Human rights.
But in the human rights context, but in the property context, which is the context that's relevant here for expropriation, international law governs the relationship between sovereign states. So if there is no affront to another sovereign state, there is no violation of international law. There may be violations of local law, as Article Article 175 tells us there may be, if there's a separate treaty or a local law or an agreement with an individual, that may allow an individual to have rights or claims. But international law itself requires a relationship between two sovereign states. That's what the the 11th Circuit explained in Messerhain. And it's what the Supreme Court held in Philipp when it addressed the expropriation exception, right? There has to be an injury to another sovereign. And within international law, the individual and his or her property have no independent existence. It's the sovereigns.
Isn't it also the case that, at least I think we held, that FISA is not a remedy statute. It's a jurisdictional statute.
Exactly.
And
right,
in
Judge.
order to obtain jurisdiction, you have to, because of sovereign immunity, you have to fit yourself within one of the exceptions. One of the exceptions is expropriation. But the Supreme Court held that the expropriation exception doesn't apply if the individual is not a citizen of another state.
That is exactly correct, Your Honor, and that was my second leg of my answer to your question, Judge Fuller. I'm sorry I didn't get to it, but you said it, Judge Randolph. So in McKesson, this court held that the FSIA does not provide any remedy. It is purely a jurisdictional statute. And so it can't be that the FSIA provides a remedy or cause of action for a claim that would otherwise lack a remedy. But more importantly, jurisdictionally, as Judge Randolph said, there has to be a violation of international law. The international law regulates the relationship between states. If one nation takes property of the national of another nation, it reduces the wealth of the other nation, and therefore it is an affront to that other nation. And therefore, the Supreme Court told us in Philipp, it implicates international law. If a nation takes property from its own national or a stateless person, that may be a grave injustice to that individual. And we all know there were grave injustices committed here, but it is not not a violation of international law because it does not implicate the rights.
Before you sit down, on the judicial estoppel.
Yes.
What is the prejudice that your clients would experience? I mean, the elements of judicial estoppel, or one of the elements is prejudice to the party.
Well, yeah, that's right, Your Honor. And I think unfairness, I think, is the way the test puts it. I think, remember, the very first decision in this case was a decision that dismissed the complaint. And this court in Simon 1, the very first appeal, we're now on appeal number 3, right? But in the very first appeal, this court reversed that decision, sent the entire case back, and you had a sovereign defendant litigating for a number of years now at every level of the federal court system, district court, this court, Supreme Court, all based on the premise that these plaintiffs were Hungarian nationals. I don't think there's any way you can read Simon 1, and I take your point, Your Honor, there was more to that decision, but repeatedly in Judge Srinivasan's decision there, the court says these were Hungarian nationals. The Article 27 is a fundamentally different provision because it deals with Hungarian nationals.
True, but as the district court held, this is a balance of equities, and we look at that under a discretion standard, and the up and down to our court and to the Supreme Court is a prerogative of your client. It's not, a requirement. You could have stayed in the district court and had factual determinations and perhaps been done long, long time ago. So, we're reviewing this issue on an abuse of discretion standard, right?
You are, Your Honor. And an error of law is, of course, always abuse of discretion. With respect to finishing out for Judge Randolph's question about unfairness or prejudice, I think you have to view this.
Well, I just want to follow up on that because I wondered, what we're dealing with is a sovereign immunity statute.
Exactly.
Right? And there are plenty of cases, Harlow versus Fitzgerald comes to my mind, a Supreme Court decision, that talks about what the prejudice is for someone who claims immunity and yet has to go through discovery and so on and so forth. And the whole purpose of sovereign immunity is to prevent that. So the very fact that you have to go again for the third time is prejudicial under Supreme Court precedents, including Harlow versus Fitzgerald, because you're being required to do something that sovereign immunity is supposed to prevent.
Thank you, Judge Randolph. That was the point I was going to try to make. I don't think I would have made it as eloquently as you would have, but yeah, that was exactly it. So you have to view this prejudice question in the context of the FSIA, and the basic objective of the FSIA is to free foreign sovereign defendants from suit, not just from liability, but from suit. And so to hail a foreign sovereign into a U.S. court, require the foreign sovereign to participate in discovery and litigation, to bear the expense, to bear what is viewed as an affront to the sovereign power of another nation, to submit itself to the courts of the United States. Those are issues that all nations face with respect to one another. There are standards that are set by the FSIA, and those standards are generally that a sovereign defendant should be freed from suit as soon as possible when a defense is available. And so I think if the whole premise of Simon 1 was that they were Hungarian nationals. Now, if we're suddenly saying they're not, then we've been subjected to years of litigation without any basis. That adds up to prejudice for purposes of the FSIA.
Right, we will give you.
But let me just ask this one thing.
Yes, sir.
But what's the additional discovery that would have to be in the case?
Well, I think that goes to Judge Pillar's observation before, that the district court seemed to base its conclusions on the pleadings and not on actual fact finding. There already was discovery, so I don't know that there would be an opportunity for additional discovery, but certainly the district court would have to find facts. The court said, well, if you look at this, plaintiff says that they were born at some point in Ruthenia, so it's not impossible that their parents lived in Ruthenia, 10, 20 years earlier. That's not a finding of fact, right? And Judge Pillard I think we certainly agree on this point, Judge Pillard, for the court to assume jurisdiction, the facts must actually show that all of the jurisdictional prerequisites are satisfied. That includes.
So that discovery
yes.
was affected on the nationality issue?
There was discovery. I don't know that, frankly, there was that either side had. We don't have facts about the plaintiff's nationality. I don't know that they put in discovery about the actual individual plaintiff's nationality, but my colleague here, who is trial counsel, may correct me on that when we sit down, and I may come back here and revise that when I come up again. But I don't know, as I stand here right now, I don't know if there was specific discovery on that. There was discovery on other issues, including property tracing. So,
Thank you.
thank you, Your Honor.
Morning, Mr. Zell.
Morning, Judge Pillar. And may it please the court. Before I respond to my friend's comments during his oral argument, I'd like to note that we have with us today some special guests. The family of Rosalie Simon, the lead named plaintiff in this case. Rosalie herself could not be here because she's teaching high school students about the Holocaust on this Holocaust Remembrance Day. But she did send her children, Mitch and Ruth Simon, and her daughter-in-law, Deborah Cohen Simon, and her great-grandson, who's writing a report about this case, Louis Simon. Also with us today is the daughter of another named plaintiff in this case, Rosalie's sister, Charlotte Weiss. Your Honors, and may I also say that, for the record, that my name is Mark Zell, and I'm representing the plaintiffs along with my colleague, David Weinstein.
And we welcome you all to court today. Thank you for being here.
And my colleagues, Chuck Fax, Charles Fax, and Paul Gaston. Your Honor, just a few hours ago in my home in Israel, millions of people dropped everything they were doing, even alighting from their vehicles in the middle of the highway, to stand in silence for the memory of the 6 million. Today, amazingly, when we're hearing these arguments, is Yom HaShoah, Holocaust Remembrance Day. Before I address the issues of statelessness and nationality under Philipp, I'd like to respond quickly to some points that my colleague, my friend, made during his oral argument regarding the rules of international law, expropriation and law under the restatement second. First, I would point out, very clear from the Philipp opinion, that the source, the proper source or description of international laws that existed at the time the Foreign Sovereign Immunities Act was enacted in 1976 is not the third restatement, but rather the second restatement. And the second restatement has, and this was quoted by the Supreme Court in Philipp, two sections that are directly pertinent. These are the sections quoted by the Supreme Court in Philipp. One is Section 185, which says that the taking by a state of property of an alien, I'll come back to that point in a moment, is wrongful under international law if either it is not for a public purpose, and we would add under Section 166 of that same restatement, is discriminatory. And discriminatory, the concept of discrimination is described in the restatement second, and it clearly applies to the facts of this case. And also you have to show, or you may show that there's not been just compensation and so on. That certainly hasn't happened in this case. The Philipp Court also cited restatement section 192, which defines the meaning of taking of property. Again, a principle of international expropriation law. And that says that conduct attributable to a state that is intended to and does effectively deprive an alien of substantially all the benefit of his interest in property that constitutes a taking in violation of international law.
But Mr. Zell, under the second restatement, you're right that there are these references to a person being an alien for purposes of the responsibility of the state for the injury under the domestic takings rule. But it also goes on, and this is the second restatement in section 175 to talk about responsibility of a state under international law for an injury to an alien, and comment D of section 175 specifically references that a stateless alien is without a remedy since there is no state withstanding to espouse his claim.
So, Your Honor asked a question along these lines during my colleague's argument. I think Your Honor put her finger on it correctly when she suggested that the qualifications in section 175 go to remedies under international law, but they don't contradict what Congress did under the FSIA in 1976. You recall that the Supreme Court in Philipp also said that the expropriation exception is unique in the world in terms of state practice and international expropriation law. There are no other countries on the earth that have a provision in their law limiting immunity in a case of expropriations, as we do here in the United States. And when Congress enacted that particular exception, it was cognizant of the situation on the state of international law, and nevertheless clearly created the possibility of an action. In other words, and here I have to clarify again, the Foreign Sovereign Immunities Act, Judge Randolph, is not only a jurisdictional statute. It has jurisdictional ramifications, but it deals, as Justice Kagan said recently in the Kassir case, that it deals with the amenability of foreign sovereigns to suit. That is the core of the statute. If they are within an exception, then the court has jurisdiction to proceed under Section 1330, Title 28. But Section 175 is a remedial concept. And it doesn't say, and what it goes on to say, by the way, that the responsibility of a state under international law for an injury to an alien cannot be invoked directly by the alien. This is not only stateless aliens, by any alien, against the state except as provided by the law of the expropriating state, international agreement about which my colleague David Weinstein will have more to say during his argument, and an agreement between the state and the alien, which does not exist here.
So you're relying on B there?
We will be relying on B. I'm not arguing that particular point at the moment. This is dealing with the effect of the Trianon Treaty of 1920 on this section. But we are relying on the expropriation exception of the FSIA, okay? Because think about this.
So how does that fit within 175? Because the FSIA itself incorporates a requirement that the property be taken in violation of international law.
Correct.
And the Supreme Court was well cognizant of the point that you just made about the uniqueness of the FSIA piercing of national immunity for purposes of recovering for expropriations. Right. And it was quite attentive to keeping that extraordinary cause of action narrow. And so I guess the bottom line question is, where in customary international law is there any support for the notion that a stateless individual would be outside of the domestic taking rule?
I have a couple of answers to that. The first one that deals with Section 171 of the Restatement Second, which defines the term alien. And when you look at that particular section, you'll see that it clearly defines it in a way: a person is an alien for purposes of the responsibility of a state for injury to an alien relating to the issues in Section 175, if he is not a national of the respondent state. Now, and then it goes on to say in comment G to that very section, Your Honors, that a stateless person comes within the definition of alien, but the responsibility is limited as provided in Section 175. And our argument is, under Section 175, Congress has superseded customary international law on this point by allowing an alien, including stateless aliens, to bring a claim against a respondent foreign state. And what I'd like to add to that is that what would happen, let's take the case of a foreign national alien.
Wait, let me just stop you there, though, because if you say that Congress has superseded customary international law, that seems to me that would have given a platform to plaintiffs in Philipp and given them a remedy that would have negated the Supreme Court's narrowing reading.
I respectfully don't agree. What Congress did in enacting this exception, let's take the example that I think will illustrate this point. Suppose the alien we're talking about is not a stateless alien, but rather a citizen of a foreign state other than the respondent state, okay? Under the reading that we have in Section 175, that alien would also not have a recourse or remedy under international law.
Well, international law supports, and I think that this is clearest in Helmreich, we walk through why expropriation is a violation of international law. So there is established law that an expropriation by one nation state of the property of a national of another nation state is in violation of international law.
That's true, but you recall my colleague citing the language in Philipp, which was basically historic, as Chief Justice Roberts was reviewing the genesis of the domestic takings rule, said that under international law, individuals in the traditional sense were never the subjects of international law. Only states had rights under international law, and individuals couldn't bring action. That changed with with the Congress's enactment of the FSA. It was an extraordinary provision. And it's true that Philipp says we have to be careful about extending it, but at the same time, we can't deny the fact that aliens who are the victims of an expropriation, either because they're foreign citizens of a foreign state or stateless, now have recourse under, at least they have the right to argue that the respondent state no longer is entitled to immunity. Now, whether they have a cause of action, well, that's not something that the FSA deals with.
Let me ask you more concretely about the claims that the district court allowed to go ahead and the claims that it dismissed. On the Lebovich sisters, if we were to look at Article 6 of the Saint-Germain Treaty as a place to start to determine the non-dismissed survivors' nationality, have the Lebovich sisters plausibly alleged that they would have acquired Czechoslovakian nationality pursuant to that provision?
Okay, so
and if so, exactly where would you point us?
That's an excellent question, and let me answer it in this way. The Saint-Germain Treaty of September 10th, 1919, provided, and the Trianon Treaty in Article 61 clearly says that anyone residing in the territories that were ceded by the former Kingdom of Hungary to the newly formed state of Czechoslovakia, and by the way, let me just point them out on this map. The purple areas, the deep purple areas, and the light blue areas on the map are the areas we're talking about. All those areas were part of Czechoslovakia until Hungary illegally invaded them in 1938 and 1939 and purported to annex them, an annexation that was never recognized by the government of the United States or the Allied powers in World War II. In any case, what the Saint Germain Treaty says and what the Trianon Treaty also says is if you were a resident of these areas at the time that the state of Czechoslovakia was formed, which was 1918, and then let's say that we'll extend that to 1920 because that's when the actual nationality law was enacted by the Czechoslovak state. Those people became citizens of Czechoslovakia, notwithstanding the fact that they were Hungarian citizens beforehand. Now, by the way, just so we're clear on the chronology here, none of the named plaintiffs was alive when Czechoslovakia became a state. The oldest of the Lebovich sisters, Helen, who's, may she rest in peace, who was born in 1922, and Rosalie Simon was born in 1931. Okay. And Charlotte Weiss was born in 1928. I don't remember the exact date. Okay, all of them were born in Czechoslovakia. Now, there is a provision, which my colleague referred to, completely out of context, and we addressed this in our brief, that Article 62 of the Trianon Treaty says if you were a person that came into these areas between 1910 and 1918, then you needed to get the permission of Czechoslovakia to obtain Czechoslovakian citizenship. But if your parents, for example, were living in those areas before 1910, and you were born to such parents after the Czechoslovakian state arose, you were a Czechoslovakian citizen.
Do we have an allegation that the Lebovich sisters were born in Czechoslovakia? You just stated that they were all born in Czechoslovakia, but I didn't see an allegation.
There is an allegation that they were born in a town called Tarachok, I think is the name. The court can take judicial notice of the fact that that town was in Subcarpathian Ruthenia. And that's the case with all of the other 9. In particular, I'd like just to point out that there is in the record two very interesting declarations, both at Joint Appendix 212 and at Joint Appendix 226. One is by Yafa Proper Daskal, who was born in those areas, and also Tzvi Zelikovich, who the district court mistakenly excluded from the class of the plaintiffs who were allowed to continue. Both of those declarations state specifically that their parents were born in these areas, and we gave the date of birth,
But
1899, 1895, whatever.
For the Lebovitz sisters, it says they were raised in Terakoc,
Okay, with the
in
11.
Hungarian annexed within. It doesn't say they were born there.
Okay, Your Honor, when this lawsuit was filed, and when these declarations were filed, the law about nationality in terms of the domestic takings rule was unsettled around the country and in this circuit. All the indications were based on the Chabad case in 2008 that this circuit was going to take a different approach. And the Seventh Circuit, in the Abelus case and the Fisher case afterwards, also took the position that the domestic takings rule wasn't applicable.
And you took the position that your clients were Hungarian, as a result of which the Simon 1 opinion spent 4 or 5 pages dealing with the 1947 treaty as a result of your representations.
Your Honor, with due respect, we never, except perhaps in one oblique reference in a reply memorandum, certainly not in the Second Amended complaint, we never, well, the Second Amended complaint wasn't filed until after Simon, of course, but we never contended that our clients were all Hungarian nationals. It just wasn't necessary. We did say.
Well, it was necessary.
No.
It was necessary, maybe not under the expropriation law in this circuit at the time, but it was necessary to sort out the treaty of.
Okay.
Is that right?
No. And again, I'm sorry to disagree with you. Okay. The treaty obligation that the Simon 1 court focused on was Article 27. And what is the operative language in Article 27, Your Honor? Persons under Hungarian jurisdiction. Doesn't say anything about Hungarian nationals. Persons under Hungarian jurisdiction. All of the plaintiffs in this case, all of them, were under Hungarian jurisdiction to their chagrin when these mass expropriations took place in 1941 and 1944.
Because the Greater Hungary had annexed.
Had attacked these areas and annexed them illegally. Yes, in 1938 and 1939. That's exactly the fact. They were under Hungarian jurisdiction. The court in Simon 1 was imprecise when for example, it says in the opening paragraph to the decision that 14 plaintiffs, all the named plaintiffs were Hungarian nationals. Simply not true. They were not. And it wasn't really necessary for the court to delve into that. The only important point was the expropriated property was located, and the people themselves were located in these illegally annexed areas, the light blue and the purple. And that is the case. I don't mean to disagree with you, Judge Randolph, but I'm trying to.
That's what we're here for.
Yeah, there's a lot of imprecision on both sides.
Right.
Okay, frankly, in this case, it's confusing.
Yeah.
And the law is shifting. You know, we've had since Simon 1, we've had Helmerich, we've had Philipp, and now last year Kassir, where the plaintiff in Kassir was a German national whose property was expropriated by Germany. Right. And the Supreme Court reached the issue of choice of law after trial in it.
Yeah, but they never addressed the questions.
Well, they didn't address it specifically, but that's the underlying predicate. Okay, and they must have been very well aware of it. The other thing I'd like to point out is that during oral argument on the Philipp case, something was very interesting. When you look at the transcripts of the oral argument, I have them here. Probably 5 of the justices all asked questions about what would be the result if Hungary or Germany, in the case of Philipp, completely stripped these plaintiffs of their citizenship. Now, why would they ask that question? Why would particularly Justice Gorsuch in our case, in the argument asked our counsel, that question, almost a page of the transcript deals with this precise question. And our counsel had to say, listen, Your Honor, that issue is not before the court now. Okay, it wasn't briefed, it wasn't raised, and certainly in the Simon case it wasn't presented. but we need to deal with it on remand. If the court had wanted to say that these kinds of inquiries are not permitted or beyond the expropriation exception, it could have easily done so. Rather, they didn't do that. They specifically remanded Philipp, and by an extension, our case, for a determination on the question of nationality.
Mr. Zell, let me just ask you on the question of Hungary's commercial activity. Do you need us to reach both the issuance of bonds and the military purchases? Or would it have any effect on the litigation going forward if we were to only reach one?
With your permission, Your Honor, I'd like to defer that question to my colleague, because that's one of the areas in his bailiwick.
All right. Thank you.
Thank you, Your Honor.
And we'll hear now from Mr. Weinstein.
And thank you for asking that question. May it please the court, I am David Weinstein, co-counsel with Mr. Dell and Messrs. Fax and Aston. I expected to start off by talking about the Treaty of Trianon, 1920 treaty, which provides an additional reason why Hungary has no immunity in this case. However, I do want to address as well the concerns of you members of the panel who have raised questions about the treaty exception and whether or not it is applicable here. And since the panel had questions about that, I'd like to put it to rest. First of all, we know that Article 26 does not explicitly say that it is providing an exclusive remedy. That's a conclusion that Hungary would like the court to draw from what's in the treaty. They do not, however, look to other provisions in the treaty. And I'm referring specifically to Article 27. If indeed Article 26 were exclusive, Article 27 would not have been written the way it is. Article 27 talks in terms of all cases, ellipses, of persons under Hungarian jurisdiction, irrespective of their nationality. So it is clear that Article 27 would not be dealing with all cases of discriminatory taking if, in fact, the intention was not to include all cases, but instead to look or require the parties to look exclusively to Article 26. And consequently, it cannot be the case that Article 26 is an exclusive provision. And indeed, there would have been no need for the 1973 executive agreement, Judge Randolph, as you asked, if in fact Article 26 were exclusive. On the contrary, it would be a nullity because Article 26 would have been exclusive. So with that put to rest, I do want to come back to the Trianon Treaty because it provides a separate additional reason why there's no immunity. The Trianon Treaty is the treaty between the Allied powers and Hungary at the end of the First World War. There were similar treaties entered into by the Allied powers, with other countries, including, for example, Austria and Czechoslovakia. The portion of the treaty specifically refers to the protection of minorities. And if, let me put it this way. Article 58 specifically says Hungarian nationals who belong to racial, religious, or linguistic minorities shall enjoy the same treatment and security in law and in fact as the other Hungarian nationals. It doesn't say, oh, except with regard to property or except with the right to vote or any other indicium of nationality.
So the difficulty, I think, is with the Supreme Court's decision in Philipp. And I mean, I hear you that the reading, that the rationale there is, you know, we're going to set aside as a potential source of international law, international human rights law, and we're going to look only to international law, meaning state-to-state law. And a treaty is state-to-state in that sense. So that would support your reliance on Trianon. But the court also repeatedly, and in material ways in the Philipp opinion, refers to the international law of expropriation as the only international law that the expropriation exception refers to. And I don't see any reference in the Trianon Treaty provisions you say to property, to expropriation. It's hard to see it as a source of international law of expropriation.
Well, the answer from our perspective, Your Honor, is that all cases means all cases, and that has to include a subset of the all cases being those cases involving property. It by its nature, that provision is exclusive in the sense of saying every kind of case. So whether or not it might also refer to what Your Honor has called human rights law, it doesn't eliminate the fact that it also involves property rights. And it's the taking of rights in property in violation of international law that Section 1605A3 says. Okay? And we are saying that this involves rights in property. And it's also clear that the treaty, by its express provision, says that it is addressing matters of international concern. So we, as Your Honor indicated, we are aware that this is a matter of international, state-to-state legal provision. Your Honor had asked Mr. Zell a question in a different area of the law having to do with the commercial exception, and he deferred any questioning of that to me, and I'd be prepared to address. I would appreciate your restating it. It's a little bit harder for me to hear the question when I'm sitting over at council table, but I certainly don't want that question to go unanswered.
So I guess the question that I had asked Mr. Zell was whether it has implications for the case going forward, whether if we were to accept your allegations about commercial nexus, whether we would look to the issuance of the bonds vis-a-vis the United States or the military purchases. Does it matter if we accept only one, or for the case, for the litigation, were the litigation to proceed? We have two bases.
I think the answer to it is, at least at this stage, the district court made a factual finding based upon stipulated evidence that there was limited discovery, and that can answer the question you asked opposing counsel. There was limited discovery in this case only after the second remand, and it was to develop the question of that Your Honor has addressed today. That is to say, whether there was commercial activity. And the parties resolved much of that with a stipulation when we got into a debate about the motion to compel production of evidence that we had to file because of objections filed by Hungary. It was all resolved by a rather extensive stipulation that's in the record. And the evidence, therefore, is there. So whether one later on will need to do anything further on that specific point is probably doubtful at this point, because that is a stipulation of the parties as to the facts. So therefore, the military purchases and the sale of bonds in the United States are fact.
But the defendants point to, in terms of the military purchases, whether that is really the kind of activity that would fall outside the restrictive theory of immunity, and with respect to the sale of bonds, they assert that there's an intermediary that's really responsible for that. So there are issues where they're defending against one or the other in ways that have to do with, I think, as yet unresolved legal questions.
There may be undeveloped questions in regard to agency, but I'm not so sure that that's the case, because the evidence that of agency, for example, that the entity that allegedly issued the bonds didn't, because they were issued in the name of the Republic of Hungary, and the person from the alleged agency actually was signing in his capacity as the attorney for the Republic of Hungary. Those kinds of factual questions are there. If after remand there still remains some lacuna of evidence that needs to be developed, I'm sure the district court can address those issues. But I believe what remain are the conclusions that Judge Howell reached concerning what actually was the case. And the other issues are legal issues that are already squarely before the court in our briefs and Hungary's briefs.
All right.
So if I may, just in conclusion, we ask that the court affirm the denial of the motion to dismiss with respect to those survivors who were from Czechoslovakian territory. And we ask that the court vacate the dismissal with respect to all other plaintiffs, both in this case and in the Heller case. Case be remanded for further proceedings, including finally an answer to be filed by the two defendants. Thank you, Your Honor.
Thank you. So I believe that Mr. Silbert ran out of time, but as I said, we would give you some time for rebuttal. We'll give you 3 minutes.
Thank you, Your Honor. I appreciate that, and I will try to be quick. I believe I heard my friend, Mr. Zell, clarify the plaintiff's position that Congress superseded customary international law in the FSIA. I don't think that can be right. It expressly incorporated international law, and that was clear in the Supreme Court's decision in Philipp. Judge Randolph, you asked whether it mattered, was necessary that the plaintiffs were Hungarian nationals for purposes of the argument in Simon 1. It absolutely does. And one reason you can see that is by reading section 26 of the 1947 peace agreement. It deals specifically with the case of Czechoslovak nationals who lost property by reason of force or duress in territory that was annexed by Hungary. You can see from the map that the plaintiffs have brought you that they lived in exactly that territory. So if they were Czechoslovak nationals rather than Hungarian nationals, then by the express terms of Article 26, their claims would be covered by Article 26, not by Article 27, which is the provision the court analyzed.
Did they argue that Article 26 was irrelevant to their claims?
They did, Your Honor, and that relates to their response to your question about the executive agreement. So I think what I believe I heard Mr. Weinstein say here is that those executive agreements were separate from Article 26. They were not. And in fact, in the plaintiff's reply brief, and we quote this in Simon 1, and we quote this to you at page, I believe it is 48, but I know the clerks will check me of our reply brief. The plaintiffs argued that those international agreements, including the 1973 executive agreement, all relate to Article 26. They were right the first time. Those are agreements that are addressing Article 26 rights. Nothing in Article 26 prevents state-to-state negotiations about rights covered by Article 26. In fact, there's another provision, Your Honor, Judge Pillard, you mentioned Article 40 earlier. There's a different provision. It's Article 35 of the 1947 peace agreement, deals with disputes involving Article 26. But all of these provisions allow for state-to-state negotiations and agreements with respect to those rights. What they don't allow for, Article 26 does not allow for, is a private cause of action in a United States court for the same property rights that are addressed by Article 26. Yes, Your Honor.
I'd like to hear your response to the argument about the restatement 171 and 175 and aliens.
Right. So for some purposes, a stateless person may be considered an alien because he or she is not a national of that state. But the international law of expropriation, the Supreme Court told us, is implicated because the taking of property from the foreigner constitutes an injury to the foreigner's state of nationality. And in comment D of section 175, which is the very comment that that my friends the plaintiffs rely on, it says a stateless person would have no remedy if they do not come within that exception. Now, I believe if you combine Mr. Zell's and Mr. Weinstein's argument, Mr. Zell confirmed that the provision, the exception of 175 that the plaintiffs are relying on is B, treaty, right? And the treaty that they are relying on is the Trianon Treaty. And I think it was clear from the colloquy with Judge Pillard and others with Mr. Zell, the Trianon Treaty is not the customary international law of expropriation that the Supreme Court referenced in Philipp. So their 175 argument really comes down to their Trianon Treaty argument. They say the Trianon Treaty is what triggers the exception, but that Trianon Treaty, or Trianon, I'm not sure how it's pronounced, but you know the treaty I mean. That treaty is not the customary international law of expropriation, which is the only law referenced.
You're not arguing that it can only be customary international law. If there were a treaty about expropriation, then that would apply under B. You're just saying this is not that treaty.
That may be, Your Honor, but that question is not even before you.
And it wasn't before the Supreme Court.
Was not
so it's not limited. We can't really fairly read the Supreme Court's Philipp opinion to be limited to customary international law. That's just the only argument that was proffered there.
May be true, Your Honor, but that question is not before you even in this appeal because the provisions of the Trianon Treaty that plaintiffs rely on, which specifically are Articles 55 and 58, make no reference to property. What the plaintiffs say is, well, they protect civil rights, political rights, free exercise. Those things may have in them property protections. Okay, maybe I don't see that. I think where the treaty addressed property rights, it said so, and those were the provisions dealing with UN nationals, right? But in any event, those provisions are not expropriation law. They are civil rights law and free exercise law. So under the Supreme Court's decision in Philipp, they do not come within the expropriation exception.
Thank you.
Thank you, Your Honor. Thank you very much.
And Mr. Zell, I think you have 1 minute.
Your Honor, one of the points that I was unable to make during my very extended argument, for which I thank you, concerns the position that our amica curiae, Professor Vivian Curran, who's here today with us, and she made about the Philipp case before, 2 years before Philipp, she said Simon 1 was not an appropriate interpretation of the rights and property in violation of international law language. Rather, she said the appropriate focus needs to be on nationality. And the nationality issue, she said, needs to be resolved in what she described as a concept of substantive citizenship. I'll boil that down to one phrase, and that is, the question is, with regard to the nationality of the Jews from Randolph in Hungary, that white area, did Hungary at the time of the expropriations in 1944, in their case, consider its Jewish population as Hungarian nationals? I submit to Your Honor that the answer to that question is unequivocally no. And with the result that those people were stateless, and for the reasons that I've discussed earlier, the stateless persons are outside the domestic takings rule. Thank you, Your Honor.
Thank you. The case is submitted.
Case number 22-7126, Alan Philipp et al., appellants versus Stiftung Preussischer Kulturbesitz. Mr. O'Donnell for the appellants, Mr. Fryman for the appellee.
Good morning, Mr. O'Donnell. You may proceed when you're ready.
Good morning, Your Honor, and may it please the court. Nicholas O'Donnell for the appellants, Alan Philipp, Gerald Stiebel, and Jed Lieber. To understand the two questions posed by the Supreme Court on remand, it is essential to understand the role that the nationality of the victims has always played in this case. This case was brought in 2015, alleging a classical expropriation of the property at issue. You look at paragraph 23 of the first complaint, which is the joint appendix at page 21, at 19 and 20, excuse me. It's very clear that the allegations were framed in terms of a classical expropriation. This is not a case that took a turn because of Simon 1. The allegations are that the Welfenschatz, the property issued in this case, that taking was discriminatory because the victims were Jewish, that it was not for a valid public purpose, it was part of the Nazis' larger theft of art, and that there was not fair and adequate consideration paid at the time. This appears verbatim in the first amended complaint at paragraph 25, joint appendix 177, and the second amended complaint, paragraph 25, joint appendix 908. Those allegations set out the elements that even the Prussian Foundation would have to concede address what international law prescribed. These allegations, as I said, did not change because of Simon. They were not an adaptation because of an intervening case. even if you looked at Simon 1 as an outlier, which it was not at the time, it is extremely detailed. The allegations are extremely detailed about the role that being a German or not being a German by virtue of being a Jew in so many words played in why this transaction fits those elements.
So JA 908?
908, Your Honor, I believe is the second amended complaint.
Yeah, paragraph.
25 of the second amended complaint is verbatim paragraph 23 from the first complaint. If I've given you the wrong JA site, I apologize.
Yeah, I think it's on 903.
903, I'm sorry.
What paragraph?
Paragraph 25 of the operative complaint before you, the second amended complaint.
And that's the same as First Amendment amended complaint, paragraph.
25, and original complaint, paragraph 23. And when you compare them, they are verbatim the same. This case in 2015 invoked section 1605A3. The jurisdictional theory of this case has never changed. It is that this transaction cannot be defended because of who the parties were. And if I say nothing else today, it is that the motivating philosophy of the taking state, or the expropriating state, is to divide the universe into Germans and non-Germans. And I think Mr. Zell said this eloquently at the end. If you were to ask what the view of the expropriating state was in 1935 as to whether these three men were German nationals, the question answers itself. Of course, Germany did not. Germany could not have been more emphatic that this group of people was constitutionally ineligible.
Why is that the issue?
Because that is how you determine what the nationality of the parties is, Your Honor.
What about the corporations? These individuals did not own anything, and their heirs didn't own anything except the interest in a corporation. Three corporations were German corporations.
The dealership
that sold the artwork in 1935.
That is correct, Your Honor. We disagree with the Prussian Foundation, of course, as to whether the association had separate existence. But going to your question about the art dealer firms, that simply puts them in the same place as the plaintiffs in Helmerich on the remand. The American shareholders, whose Venezuelan corporation was taken. The Venezuelan corporation had no grievance under international law, this court held. But the American shareholders did. And in this case, what you have at the time of the taking is you have two shareholders who must be considered Dutch because they had left. And again, this goes to the standard of nationality of the men involved.
I have to interrupt you. That's not, what you just said is not accurate according to the Supreme Court. Let me read to you. It says 2 of the consortium members fled the country following the sale.
That is, with all due respect to the opinion of the Supreme Court, Your Honor, not what the allegations of the complaint say and what the allegations of the complaint have always said.
So Chief Justice Roberts was wrong.
I guess in that respect, yes, Your Honor. Just as to the record of the case. The record of the case, it's not disputed, has never changed as to the sequence because it says by 1935, they had emigrated.
It says by, but the sale was in June.
Right, and 1935 began in January. So by 1935, without any more specific reference, is by the time 1935 began.
But your entire theory also depends on the ability of stateless individuals to assert expropriation claim.
Not entirely, Your Honor, because I think under the proper perspective, Rosenberg and Rosenbaum must be considered Dutch nationals at the time of the taking, which would place that into the context of what everybody, I think, agrees, putting aside the corporate question Judge Randolph addressed, is a classical expropriation, taking by a state of a foreign alien's property. But even as to the statelessness question, Your Honor, yes, we agree certainly with assignment plaintiffs. And I think the way to look at that is there is this small space, right, between the second restatement and the FSIA. There has to be, because as Mr. Zell pointed out, there is no analog in customary international law for the expropriation exception.
I want to get back to the question I asked you earlier. The allegations, I'm looking at your second amended complaint, and just, there are a number of paragraphs, but just take paragraph 32. On information and belief, the consortium was solely entitled to ownership rights in the period October 1929 to June 14th, 1935, when the artwork had been in their possession. So the consortium sold it. And then according to the Supreme Court, the two individuals you're talking about moved to the Netherlands, right? So when the taking occurred, they were not Dutch citizens. And if that's essential, I don't find it, if it's essential that they be considered Dutch citizens, show me in your complaint where you'd make that allegation.
It's not essential, Your Honor. Well, as I said earlier, we made the allegation that by 1935, they had emigrated. So I understand what the opinion in Philipp says, but as to what the record is, which is the question, which is the record we're examining on the remand question, the allegations are as they've always been. But it is not essential because stateless victims can bring these claims. They can espouse these claims, and that is for a couple of reasons. One is the comment D to Section 175, which Mr. Zell alluded to, is that in that instance, the stateless alien can espouse the claim. And the other, as I said, in response to your question, Judge Pillard, is there has to be, by definition, the very, at least slightest bit of space between the second restatement and the expropriation exception, because there is no analog at international law. Now, as the Supreme Court has said repeatedly, it is a departure, but not a radical departure. But it has to, that Section 1605A3 is a departure from international law, but it should not be considered a radical departure. Justice Thomas quoted that at me in oral argument. It is in various expropriation decisions by the Supreme Court since the 80s. But the departure has to include something greater than zero. Otherwise, the expropriation exception in that instance would have there would be nothing left.
Well, it's about the immunity. It pierces the immunity. I'm not sure how you're relying on comment D, the last clause of which is a stateless alien is without a remedy, since there is no state withstanding to espouse his claim. And there you're relying on the notion that the Foreign Sovereign Immunities Act creates.
Well, Section D ends, unless I'm reading the wrong paragraph, under the rules stated in this section, a stateless alien may himself assert the responsibility of a state in those situations where an alien who is a national of another state may do so.
And the next sentence is, however, in those situations not covered by the rules stated in this section or by an international agreement providing some other remedy, a stateless alien is without a remedy.
But the FSA is that remedy.
Since there is no state withstanding to espouse his claim. And it seems somewhat circular, whether the FSIA is referring to property taken in violation of international law, and then you're saying, well, violation of international law need not be separately provided, for example, as described in the second statement or described in other sources of customary international law, because the statute itself accomplishes that codification?
That goes back to the fact of the FSIA and some of your questions earlier today, Your Honor, which is that the FSIA does provide that remedy. The FSIA does a lot of different things. And the day before the FSIA was enacted, an alien in that circumstance would have had no remedy anywhere.
So you are relying on the distinction between right and remedy
Yes.
that I alluded to at the beginning.
Yes. Yes. With that, I have about a minute left, so I'll reserve the balance of my time if there are no other questions. Thank you.
Morning, Mr. Fryman.
Good morning, Your Honors. May it please the Court. Jonathan Fryman for SPK. Your Honors, I do want to address some of the jurisdictional merits questions, which of course have consumed the bulk of this Court's questions and answers this morning, but I'm going to start by being a little more boring. And I'm going to turn to the law of forfeiture, and in particular to the fact that the district court here found that the arguments that Mr. O'Donnell has been presenting have been forfeited. And this court's review of a district court forfeiture decision is under the abuse of discretion standard. And there's a reason for that, of course. The district court is uniquely positioned to know what has been argued and to take the time to look through the record in some detail. The GSS group decision is the one that makes clear that it's an abuse of discretion standard. And as Judge Collar-Catelli found, none of this was argued below. Now, this is not a question of, can you find a paragraph in the complaint that might support a legal theory? The question is, did they argue the legal theory at any previous time in this case before it got to the Supreme Court? And the answer to that question is no, as Judge Collar-Catelli set out in very clear detail in her decision. All along, they chose a path. It had a jurisdictional theory. Their theory was that the expropriation exception allowed claims for property taken in violation of the international law of genocide. That was their theory. But we all know that there was a longstanding consensus, as Judge Breyer put it in the Altman case and as the Supreme Court put it in this case, that the domestic takings rule existed. And therefore, they always had another path. They always could have said from the beginning, no, we don't fall within the domestic takings rule because we are not nationals of Germany. None of the companies were nationals of Germany, or whatever their theory would be. None of the individuals who owned the companies, and you can ignore the company's corporate status, whatever their theory would have been. None of that is argued. You won't find any of that in any of their briefs to the district court. You won't find any of it in their briefs to this court the last time around. It's first brought up in a single paragraph in response to our assertion that it was waived in their Supreme Court merits brief.
What about the allegations of the complaint, and what about the fact that you have consistently been arguing against that position? It doesn't seem like in those circumstances that there's any notice problem, which is really what this whole doctrine goes to, the preservation. It's a discretionary doctrine. You've been alert to this issue all along. Nothing about the sequence of the decision is obviously keeps you within litigation for longer than you'd like, but these are complicated questions.
These are complicated questions, Your Honor. And I don't think this court needs to address them because I don't think the forfeiture law of this circuit requires there to be some sort of particularized prejudice. But there is prejudice here. And I know Your Honor had some doubts about this in the last argument. But there's prejudice of multiple forms, and I'd like to go through them for you. First of all, I do want to reiterate the notion of the fact that I'm, of course, representing a foreign sovereign, and the very purpose of the Foreign Sovereign Immunity Act is immunity from suit. And in the Supreme Court's decision in Helmreich, the Supreme Court makes clear, no, we're not going to adopt this non-frivolous standard because that's going to drag the litigation out. That's going to make the litigation keep going. Right? Well, forfeiture's even worse. Right? If we're going to excuse forfeiture in this circumstance, we're saying the plaintiff can bring one theory, bring it all the way up to the Supreme Court, go all the way back down, and then just start with another theory.
Who goes all the way up to the Supreme Court?
Well, we do because in fact, that's part of the notion of the Foreign Sovereign Immunities Act.
Exactly. I'm just saying that, it's a little rich, given that it is the prerogative of a nation state to appeal whenever sovereign immunity is denied, that the appeals that are repeatedly triggered by the nation state are then adverted to as a source of delay. And I think this is a tough question where there are multiple legal grounds and, where you want to have them tested all the way to the highest court. And that's absolutely your prerogative. But, there's a tension between resolving things efficiently and giving the sovereign immediate rights to appeal. You recognize that.
I hear what Your Honor is saying, but respectfully, if we had not appealed, we would have been moving to discovery. We would have been moving to factual discovery because the district court, in fact, found that there was jurisdiction under a theory that proved to be wrong, that the Supreme Court rejected.
And you might have prevailed on facts.
We might have, but the point of the Foreign Sovereign Immunities Act is immunity from suit, not immunity from liability.
I understand. I just think it's very difficult to get you everything that you want.
Yeah.
Fully reviewed accuracy and have the case decided yesterday.
Well, let me make, we're not asking for yesterday, Your Honor, but let me make clear, I think it's important to get into the details a little bit of the procedural sequence here. Again, this is why we have an abuse of discretion standard, but there was an original complaint. We moved to dismiss. One of the things we moved to dismiss that original complaint was on the basis of the domestic takings rule. They amended their first amended complaint with our permission. They amended and they didn't address it. They didn't they didn't say we're Dutch or we're stateless. They did say we were persecuted, but they didn't say we're Dutch or we're stateless or companies don't count. That wasn't in their amended complaint. And then we moved to dismiss again. We moved to dismiss the first amended complaint. And in their opposition, they didn't say, oh, well, we're Dutch or we're stateless or companies don't count. They didn't make any of those arguments there.
What do you win if you prevail on the forfeiture argument?
If the district court was correct that these arguments were forfeited, then the case is over.
That case is over, but the adjudication would have been on the basis that these people were German citizens or nationals, which would not prevent them from bringing another suit claiming that they were Dutch.
Well, Your Honor, I'm here on this suit, and I believe in this suit it was forfeited. As to what they choose to do in the future, that would be up to them.
It would preclude them, wouldn't it? That's claim preclusion, and it includes arguments, whether you've raised them or not, that arise out of the common nucleus of operative facts.
I suppose
I think that would be res judicata, and we're not called on to decide that, but.
It might well be res judicata. There might be statute of limitations issues. I don't know, Your Honor, but that would be a decision for the plaintiffs to make and arguments to be had in a further case if that's something that they decided to do. Let me turn to the minute. Well, actually, let me just mention one other element very quickly of prejudice here. One of the grounds we moved to dismiss on originally was forum nonconvenience. And of course, we didn't have the advantage at the time of knowing that they were going to claim to be Dutch nationals, of knowing that Dutch nationality law might come into play, or that they weren't German nationals and that we would need to show that, in fact, the German law of nationality was relevant in addition to whatever other German bodies of law were relevant. Well, if we'd been able to raise that at the forum nonconvenience argument stage, that might have tipped the scales for the district court. And that decision, of course, also would have been under abuse of the discretion standard. So that's another kind of prejudice that was suffered here by them not raising that argument. And again, we think the argument was forfeited, but I do, in the time that's left, want to address the merits. As Randolph, as you pointed out, the companies are the ones who were the members of the consortium. And I just want to point out, this is unequivocal in the operative complaint here. Paragraph 1, the very first paragraph of the complaint, which you can find on page 896 of the joint appendix, in talking about the Welfenschatz owners, says those owners were a consortium of 3 art dealer firms in Frankfurt. It's their allegation. It's clear that German companies, 3 German companies, were the members of the consortium that owned the property that was allegedly taken. Likewise, you can turn to paragraph 32 of the complaint, which one of you asked about earlier. That's on page 911 of the joint appendix. And here again, it says, only these 3 art dealer firms, and then it names them, were the signatories to the contracts of 1929, that's when the Welfenschatz was bought, and 1935, that's when it was sold. So the plaintiffs themselves have admitted that this property was owned by corporate entities in Germany, in Frankfurt. They have never argued that these companies were not German, nor could they. These were companies that were on the commercial register in Frankfurt, as they themselves have acknowledged. And there is no doubt that under international law, the corporate reality has to be recognized. This court holds that in Helmrich, and it's a longstanding customary international law principle. It goes back to the Barcelona traction case, which is cited in this court's decision in Helmrich, as well as in the United States amicus brief in Helmrich. So it's very clear, Dr. Randolph, going to your earlier questions, that yes, you do have to care that companies owned this, that this was not individuals. So
would you turn to, while we're on the appendix, I think it's 1019, 18 and 19.
I'm sorry, Your Honor, I missed that page.
1018.
1018? Your Honor, that appears to be, if it's 1018 of the joint appendix, I see a...
1018 and 1019.
Yes, I see a list in German on page 1018.
Prussian stamp tax on the right.
Yes, I do see.
You there? Okay.
Yes.
On the left, is that the bill of sale? It's in German.
Your Honor, this is, I believe, a list of the items that's part of the 1935 contract, which begins on page 1011.
Right, and it's dated Berlin, June 14th, 1935, which was the date of the sale.
That's correct, Your Honor.
Okay, now look at the next page. And it's a Prussian stamp tax apparently imposed on the sale. And down the bottom, down in the bottom, this is the translation. It gives the date June 14th, 1935, expected, right? You see that?
Expected illegible on 6/14.
Okay, then look at the third entry. It's Mr. Rosenbaum and Mr. Rosenberg, and their address is Amsterdam.
Yes, Your Honor.
Am I to infer from that that they were living in Amsterdam at the time of the sale?
They may have been, Your Honor. The complaint, as Mr. O'Donnell's correct notes, states that they had emigrated to the Netherlands sometime between 1933 and 1935.
But it's not clear when.
But let me go to
Well, the reason I'm asking you is because under taking law, that particularly as the Supreme Court interpreted here, the question is what the nationality was at the time of the sale.
That's correct.
So if they were not in Amsterdam at the time of the sale, then the nationality clearly seems to me is German, whether by the individuals or the corporations, either way. But if they were in Amsterdam at the time of the sale, it might be a different matter, particularly since if you go further in the appendix at page 1020, can you turn to that?
Yes, Your Honor.
They're listed as former owners of the company.
Yes, Your Honor. So let me say two things.
And there's another entry, I've forgotten where it is, that indicates that by September of 1935, their company was defunct.
Well, there are, in fact, the complaint states that the company continued operations in Frankfurt until 1937, with one of their brothers running the operations in Frankfurt.
Oh, I think you're right. Yeah, I have to correct myself. I think it was a 1941 entry that said it was defunct.
I believe that they alleged that the company continued operations until 1937 and that it was removed from the commercial register in 1938. That is, that the company became defunct in 1938. Our expert on German law notes that this is a company in Winesdown, and that these two individuals are acting for the company in Winesdown, and they're, of course, collecting the assets before they're distributed to the owners of the company. But it's still a company, and that's why it's listed as three. That is, they're not separately listed as 3 and 4. It's a single unit. But so it's still a company, and Barcelona Traction and this court's decision in Helmreich are still relevant. But let me go to the deeper question that Your Honor asked, which is, what if we ignore corporate nationality? Were these two men Dutch nationals at the time of the alleged taking of the property? And the answer to that is unequivocally no. Under the international law of nationality, you look to each state's nationality law. And there is nothing in the record the plaintiffs have put forward suggesting that these two individuals were no longer German nationals in June of 1935 or that they were Dutch nationals. In fact, the only materials that this court has in the appellate record are the laws, the relevant laws, as well as experts' analysis of the laws of both the Netherlands and of Germany. And under German law, Professor Jan Thiessen points out that these people clearly were nationals of Germany. The mere fact of leaving Germany, even if you did not intend to return, did not mean that you lost your German nationality under German law. By the same consequence, Professor Kampfens, with regard to Dutch nationality law, and she attaches all of that law, which was available to the district court. Under Dutch nationality law, it was simply not legally possible to become a national within 2 years. Under Dutch nationality law, it was a minimum period of time of 5 years before you could even apply for nationality. Right? Someone doesn't become a national just because they go there, even if they intend to live there. You don't become a national of the United States because you come here on a work permit or a tourist visa, or you come here as an undocumented person. You become a U.S. national if, in fact, you apply for and receive either legal permanent residency or citizenship in the United States. Same in the Netherlands. In the Netherlands, you needed to wait 5 years to even apply. Well, 5 years, even taking them at their, they've left themselves a 2-year window. If we take the beginning of that window, 1933, they couldn't have become Dutch nationals until at the earliest 1938. So we're talking about years after the sale in issue here. And again, returning to German nationality law, it's clear that they were German nationals in June of 1935. And they put forward nothing. Their argument simply is ignore that. They say ignore what the actual laws of Germany and the actual laws of the Netherlands are, and instead just look at the totality of the circumstances. You decide in the abstract what constitutes nationality. You decide if a country and a person have enough of a link. And I want to point out that they have nothing to support this. There's no source, a steep climb, I believe, Judge Pillard, you referred to earlier. It's a steep climb to find a principle of established, customary international law, which is, of course, based on the practice of nations, other nations, based on a felt sense of legal obligation. Well, it's a steep climb indeed, and they've pointed to nothing that suggests that someone loses the nationality of their birth because of mistreatment or because of some totality of circumstances analysis. They don't cite a single case. There's no international law on that whatsoever. What they're trying to do is the same problem that happened in the earlier Simon decision. They're trying to put a square peg in a round hole.
Is there any de facto statelessness by virtue of the persecution?
There's not, Your Honor. There's no established. Matter of fact, if you look at, there was reference earlier to Section 175 of the Second Restatement, and that was not raised by plaintiffs in this case. Because, as I noted, they forfeited the whole thing, but they didn't even raise that restatement section in their appellate briefing in this case. But if you look at that, if you look at the second reporter's note to that section, you'll see the reporter saying, I'm paraphrasing, but the reporter says, wow, the law of statelessness is really not clear. And that's why we're trying to develop international conventions to deal with it. And they reference something called the Harvard Draft, which is a convention that I believe never entered into force. But the desire, I understand the desire, is to apply human rights principles to the notion of nationality because of stateless people, not having any kind of protection. But as the Supreme Court held in Philipp, we look to the relevant body of law. Human rights law exists on its own. Nationality law is separate from that. And speaking to Judge Pillard's point earlier, Judge Childs, the international law of expropriation is the relevant body of law that we look to in claims under the expropriation exception.
And then with respect to the forfeiture issue, does it matter about plaintiff being in the status of an appellee with respect to the argument?
No, because they're the plaintiff below. So we're looking at what happened in the district court, as Your Honor knows well. We're looking at what their arguments were. So we moved to dismiss, and in their opposition to the motion to dismiss, or in their amendment the first time around, they could have tried to plead around or argue around these issues. They didn't. That argument was never raised. So that's always the case for a plaintiff's forfeiture, that a plaintiff needs to respond to the arguments made by a defendant in a motion to dismiss or a motion for summary judgment.
Sir Fryman, if one were to move beyond the forfeiture and address the question of at least statelessness, if not Dutch nationality, is it preferable to rest on the lack of customary international law supporting the notion that individuals become stateless by virtue of experiencing persecution, or alternatively to hold that a state's taking of a de facto stateless person's property, assuming that the person is de facto stateless, does not violate international law?
Well, I think this court can and should present both. Right? There is no customary that precludes a state from taking the property of a stateless person. So that's unquestionable. The other proposition is clear as well. So in either event,
even a de jure stateless person, no international law preventing that.
That's correct.
It's not just a question of no nation state to champion that person's.
Right. What Philipp, obviously the central animating principles of Philipp in describing what the international law of expropriation talks about, the traditions of international law being concerned with the relationships between states, not between states and individual persons. Human rights law later emerged to deal with the problems of a state's mistreatment of its own people. But with regard to the traditional international law of takings, which is what we're looking at here, that only involves relations between states. So there's no harm to a state that occurs when a stateless person's property is taken. And I guess one way to make that very clear for you is if we imagine that the state takes the property of a person from another state, it's that other state that traditionally has the claim that can espouse that claim. And that state can get the money. That state decides whether it gives the money to the individual or not. It belongs to that other state, James and Moore versus Regan, going way back. But so, there's no, in the international law of takings, even in that circumstance, which clearly falls outside the domestic takings rule, there's no concern with the rights of the individual. This just isn't the body of law that addresses that. That's what human rights law is.
Thank you, Mr. Fryman.
Thank you, Your Honors.
We have 1 minute remaining for rebuttal.
Thank you, Your Honor. To quickly address where Mr. Fryman ended, if that interpretation of Section 1605A3 were correct, there would be no expropriation exception because all foreign nationals fully vested with the citizenship of another country would be equally without remedy, as Mr. Fryman just said. It would be for their state to bring. The FSIA doesn't do that. With regard to the preservation question, it cannot seriously be suggested that we never argued or said these people weren't German. We said so in so many words, in the complaint, in the amended complaint, in our opposition to the motion to dismiss. And
I believe you only said they emigrated.
No,
I don't believe
we
there's
said
any assertion about national.
we said the plaintiffs were officially no longer considered German. This is in our opposition brief. The SBK can't decide whether it's the brief or the complaint that controls, but either way, we said it over and over and over again. And today, as Mr. Zell said, is Yom HaShoah, and for the Federal Republic of Germany to argue that somehow it is unfair to embrace the context of what it did is absurd. And the source of international law that I would point to is what everyone outside this case understands to be true, which is that the Nazi Party refused to recognize Jews as Germans. Thank you.
Thank you all. The case is submitted.